There is a conversation that happens every single day across Australia. A pensioner picks up the phone to call Centrelink, or they walk into a service centre, or they sit down with a compliance officer, and without realising it, they say something that costs them money, sometimes a little money, sometimes a lot. And in some cases, that one conversation triggers a review that goes back years and ends with a debt notice that changes everything. I want to be very clear about something before we go any further. This video is not about teaching you how to lie to Centrelink. It is not about helping you hide assets or conceal income. Fraud is serious, it is illegal, and it is not what we are discussing today. What we are discussing is something entirely different. We are talking about the well-meaning, honest, completely innocent things that pensioners say to Centrelink, that are misunderstood, misrecorded, or misapplied in ways that end up costing them their entitlements. We are talking about the statements that sound harmless but are anything but, and we are talking about the information that Centrelink does not need from you, that you volunteer anyway, and that creates problems you never anticipated. Because here is the truth. Centrelink is not your financial advisor. It is not your counselor. It is not your friend. It is a government agency with a compliance mandate. A data matching system connected to almost every financial institution and government body in the country, and the legal authority to recover payments it believes were made in error. Every word you say to Centrelink is noted. Every piece of information you volunteer is potentially assessed, and the system is not designed to give you the benefit of the doubt. So today, I am Professor David Henscher, and we are going to go through the 5 things pensioners should never tell Centrelink. Not because honesty is wrong, but because understanding how your words are interpreted by this system is essential to protecting the pension you have earned and deserve. By the time we finish today, you will know exactly what these 5 things are, why they create problems, what happens when you say them, and what you should do instead. We have a lot to cover, so let us get straight into it. Before we get to the 5 things, I want to give you some important context about how Centrelink actually processes information, because most pensioners have a fundamental misunderstanding about this, and that misunderstanding is at the root of most of the problems we are going to discuss. When you call Centrelink or attend an interview, the person on the other end of the line or across the desk is not making nuanced judgments about your situation. They are entering information into a system. That system applies rules automatically, and the rules that system applies are not always the same rules that a reasonable person would apply if they sat down and thought carefully about your individual circumstances. The system is designed to process millions of cases. It is not designed to understand context. It is not designed to recognize that what you said is not quite what you meant. It records what was entered, and it acts on what was entered. This means that something you say casually, something you mention in passing, something you bring up because you want to be transparent and cooperative, can be entered into the system in a way that triggers an automatic outcome you never intended and never anticipated. And once that information is in the system, it is extremely difficult to undo. This is not Centrelink being malicious. It is Centrelink being a large bureaucratic system. But the practical effect for you as a pensioner is the same. Your words have consequences that go far beyond what you intended when you spoke them. And knowing which words to be careful about is one of the most valuable pieces of knowledge a pensioner can have. Now let us get into the 5 things. If you are finding this useful, and you want to stay informed about the rules and changes that affect your pension, please take a moment right now to subscribe to this channel and turn on notifications. Every week, we cover the information that Centrelink does not make easy to find, and staying ahead of it is the best protection you have. Now let us continue. Thing 1. Telling Centrelink about money you are looking after for someone else. This is one of the most common and most costly mistakes pensioners make. Here is how it typically plays out. You are looking after money for a family member. Perhaps your grandchild has a savings account, and you are the signatory. Perhaps your adult child asked you to hold some funds temporarily while they are between bank accounts or going through a difficult period. Perhaps you received money from a family member to pay for a shared expense and you have not spent it yet. The money is sitting in your account. It is not yours. You know it is not yours. And when you speak to Centrelink because you want to be transparent, you mention it. The problem is that Centrelink does not have a box to tick for money you are looking after for someone else. What Centrelink has is a box for financial assets in your name, and money sitting in a bank account in your name is a financial asset in your name. The moment you tell Centrelink that money is in your account, regardless of who it actually belongs to, it can be assessed as your asset. And if that assessment pushes you over the asset's test threshold, your pension reduces or stops. Now, the legal reality is more nuanced than that. If money genuinely belongs to someone else, and you are merely holding it, there are formal legal mechanisms, such as a trust arrangement or a formal account structure, that can distinguish between your assets and assets you hold for others. But those arrangements need to be properly documented before the fact, not explained verbally after the fact to a Centrelink call center operator. What should you do instead? If you are holding money for someone else, seek advice from a financial counselor or a solicitor about how to structure that arrangement correctly before you say anything to Centrelink about it. A properly documented trust or nominee arrangement is not the same as money sitting in your account while you tell Centrelink verbally that it is not really yours. Documentation protects you. Verbal explanations do not. Thing 2. Telling Centrelink you are thinking about selling your home. This one surprises people, so let me explain it carefully. You have been in your family home for 30 years. The children have moved out. The house is too big. You are thinking about downsizing. Maybe you mentioned to a Centrelink officer during a routine review that you are thinking about selling and moving somewhere smaller. It sounds like harmless information. It is not. Here is why it creates problems. Centrelink assesses your current situation, not your hypothetical future situation. Your home, the one you are currently living in, is exempt from the assets test. That is clear. But the moment you indicate to Centrelink that you are thinking about selling, you have introduced the possibility that your asset situation is about to change significantly. And Centrelink may flag your record for a review at the time of the sale, or note that a change is anticipated. That in itself may not cause immediate harm, but it creates a record. And that record can have unintended consequences. More importantly, the act of telling Centrelink you are thinking about selling puts into the system information that may be acted on prematurely or incorrectly. If a Centrelink officer misunderstands your comment as indicating you have already sold or that the sale is imminent, incorrect actions can be triggered. And correcting those actions takes time, causes stress, and can temporarily disrupt your payments. The broader principle here is this. Centrelink needs to know what has happened. It does not need to know what you are thinking about, what you are considering, or what you might do in the future. Pensioners who overshare future plans with Centrelink often find those plans being treated as present facts by a system that is not designed to process intentions, only events. What should you do instead? When you are ready to sell your home, notify Centrelink within 14 days of the sale completing as required. At that point, speak to a financial advisor first about the pension implications of the proceeds. But until the sale happens, there is nothing to report and nothing to discuss with Centrelink. Thing 3. Telling Centrelink about informal financial help you receive from family. This is an area of enormous confusion, and it is one where the gap between what people mean and what Centrelink hears is at its widest. Here is a typical scenario. Your adult son pays your electricity bill every quarter. Your daughter takes you grocery shopping and pays for everything. Your grandchildren give you cash for your birthday and Christmas. Your family rallies around you because you are on a fixed income, and they want to make sure you are comfortable. This is love. This is family. And when a Centrelink officer asks whether you receive any financial support from other people, and you answer honestly, you can inadvertently trigger an income assessment. Centrelink has rules about what counts as income under the income test. Regular financial contributions from family members can in some circumstances be assessed as income, depending on the nature, regularity, and amount of the contributions. This does not mean that every gift from a family member is assessed as income. For small, irregular gifts, like birthday money, the rules are more lenient. But for regular, ongoing financial support, particularly if it is substantial, the assessment picture becomes more complicated. The problem is not the support itself. The problem is the way it is described to Centrelink in a casual conversation. If you tell a Centrelink officer that your son pays your bills every month, the officer records that you receive regular financial contributions from a family member. What happens next depends on how that information is processed. And in many cases, what happens next is a review that you did not anticipate and do not understand. What should you do instead? Before you discuss any financial arrangements involving family members with Centrelink, understand what those arrangements actually are and whether they meet the definition of assessable income. A financial counselor can help you understand this. The principle is not to conceal genuine income. It is to understand what is and is not income under the Social Security rules before you describe it to someone who will enter it into a system. We are now at the halfway point of today's video. I want to pause here because what we are covering is genuinely important, and I do not want you to miss what comes next. Please share this video with someone you know who is on the pension or approaching retirement age. The information we are covering today is the kind of thing that financial advisors charge hundreds of dollars an hour to explain. It is here for free, and it is here for you. Share it, subscribe if you have not already, and let us keep going, because the next two things on our list are the ones that surprise people the most. Thing 4. Telling Centrelink, you have been helping your children financially, without understanding the gifting rules. First, we have talked about the gifting rules before on this channel, but in the context of what you should never tell Centrelink without preparation, this one deserves its own dedicated discussion. Here is the scenario. Your child is struggling to get into the housing market, or they are going through a divorce, or they have lost their job, and you, as a parent, do what parents do. You help. You give them $20,000, or $50,000, or whatever you can manage. And then, during a routine Centrelink review, or a compliance check, you are asked whether you have given any money to family members recently. And you say yes, because you are honest. What Centrelink does next is apply the gifting rules. Under those rules, you can give away up to $10,000 in a financial year and up to $30,000 over a rolling 5-year period without it affecting your pension. Anything above those thresholds is treated as a deprived asset. That means Centrelink adds the excess back into your assessable assets for 5 years, as though you still have the money, even though you gave it away. If that addition pushes you over the assets test threshold, your pension is reduced or stopped, and the overpayment calculation goes back to when the gift was made. Now here is the critical point. If you gave the money away before you understood the gifting rules, and if you have not yet disclosed it to Centrelink, the way you disclose it and when you disclose it matters enormously. Walking into a Centrelink interview and casually mentioning a large transfer you made 2 years ago without any context, without documentation, and without understanding what the rules say about it, is one of the most damaging things you can do. It is not the disclosure itself that causes the problem. The disclosure may be legally required. The problem is disclosing without preparation, without understanding what you are disclosing, and without having advice about how to present the information accurately and completely. What should you do instead? If you believe you may have made gifts above the allowable thresholds in recent years, and those gifts have not been reported to Centrelink, speak to a financial counselor before you say anything to Centrelink. A counselor can help you understand whether the gifting rules apply to your specific situation, what the likely pension impact is, and how to approach the disclosure in a way that is accurate, complete, and as favorable to you as the rules allow. Proactive disclosure done properly is always better than reactive disclosure done carelessly. Thing 5. telling Centrelink about a new companion or friend, without understanding how Centrelink defines a couple. This is the one that generates the most emotion when I discuss it, and I understand why. After losing a partner, after years of grief and adjustment, finding companionship again is one of life's genuine gifts. But the moment a pensioner mentions to Centrelink that they have a new friend, a companion, someone they spend a lot of time with, they can inadvertently trigger one of the most intrusive and difficult compliance processes Centrelink conducts. Here is why this is so sensitive. Centrelink's definition of a couple is not the same as the common understanding of a couple. Under Social Security law, two people can be assessed as a couple without being married, without being in a registered relationship, and without even living together full-time. Centrelink looks at a range of factors, including financial interdependence, living arrangements, social presentation, commitment, and the nature of the relationship. And if Centrelink decides that two people are a couple, it applies the couple rate of the pension to both of them, which is lower than two single rates combined. The financial difference over months and years is substantial. The problem arises when a pensioner, during a routine conversation with Centrelink, mentions a new person in their life without thinking through how that mention will be processed. They might describe someone as a close friend they see several times a week. They might mention that this person helps them with shopping or drives them to appointments. They might say they eat dinner together regularly. Each of these statements, in isolation, sounds completely innocent. But combined, they can paint a picture that Centrelink interprets as a de facto relationship. And once that interpretation is in the system, the burden falls on you to prove otherwise. I want to be clear again. If you are in a genuine de facto relationship, Centrelink needs to know. That is a legal reporting obligation, and failing to disclose it is a serious matter. But there is an enormous difference between a genuine de facto relationship and a close friendship, a companionship, a caring arrangement, or a social connection. And the way you describe that connection to Centrelink determines which category it falls into. What should you do instead? If your personal circumstances have changed and you are unsure whether your situation meets Centrelink's definition of a couple, seek advice before you say anything. A financial counselor or a social worker with Centrelink expertise can help you understand the relevant factors and how your specific situation would likely be assessed. Going into a Centrelink conversation about relationship status without that preparation is a risk that is simply not worth taking. Now let us bring everything together, because we have covered a lot of ground today, and I want to make sure you leave with a clear and practical framework. The 5 things we have discussed are not secrets. They are not tricks. They are simply areas where the gap between what pensioners mean and what Centrelink records is widest. And that gap has consequences. To summarize. First, money you are holding for someone else. Document it properly before you mention it. Second, plans to sell your home. Centrelink does not need to know your intentions, only your actions after they happen. Third, informal financial help from family. Understand what counts as accessible income before you describe it to anyone at Centrelink. Fourth, gifts you have made to family members. Know the gifting rules before you disclose, and seek advice if you are unsure whether the limits have been exceeded. And fifth, new companions or friendships. Understand Centrelink's definition of a couple before you describe any personal relationship to them. None of these principles require you to be dishonest. All of them require you to be informed. There is a profound difference between those two things. An honest person who is uninformed can inadvertently trigger a review that costs them their pension. An honest person who is informed knows what to say, how to say it, and when to say it. And that knowledge is the difference between a protected pension and a debt notice. Now, before we close, I want to address something that some of you may be thinking. You might be wondering whether being careful about what you say to Centrelink is the same as being dishonest. It is not. You are not required to volunteer information that Centrelink does not ask for. You are not required to provide context that goes beyond what is relevant to the question being asked. You are required to report changes in your circumstances within 14 days, to answer questions truthfully, and to provide accurate information when asked for it. That is where your obligation begins and ends. The difference between a pensioner who says everything that comes to mind in a Centrelink conversation and a pensioner who answers questions carefully and accurately is not a difference in honesty. It is a difference in preparation. And preparation, in this context, is not just allowed. It is essential. If this video has helped you today, I want to ask you to do 3 things. First, give it a thumbs up so that other Australian pensioners can find this information. Second, share it with someone you know who is on the pension or approaching retirement age. And third, subscribe to this channel and turn on notifications. Because the rules around the age pension change regularly, and the people who are best protected are the ones who stay informed. Leave your questions in the comments below. I answer as many as I can, and I read every single one. Your situation matters, and if something we covered today raised a question specific to your circumstances, please ask it. I am Professor David Henscher. Your pension is worth protecting, and knowing what not to say is just as important as knowing what to do.